Okay, and with that, let me welcome everyone to this lunchtime presentation. I'm Mark Pinto here at Phoenixville Public Library. I'm the Adult Services Director, and we are glad to have with us today from Legal Aid of Southeastern Pennsylvania, Staff Attorney Kelly Young, who will speak to us today about landlord tenant law and the basics of eviction defense. Please hold your questions until the end of the presentation, at which time I'll stop the recording, and then you can feel free to unmute yourself or put your question in the chat. And with that, we'll turn things over to Kelly. Kelly, thanks so much.
Thank you, Mark. Hi, everybody. I am going to share my screen. Now, unfortunately, my PowerPoint is not all in one in the correct order, so I might be sharing my screen multiple different times. If you ever have an issue, please just unmute and say, stop, we can't see that. I'm not the most technologically savvy person in the room, I'm sure. So let's see. And go to the beginning, and I'm going to.
Right now, we see your list of files.
Oh, okay, that's not what I want you to see.
So if you're opening the PowerPoint, then you need to share the PowerPoint screen. There we go.
Okay. Now, I would like, this is a PDF of PowerPoint slides, and earlier this morning, I was able to show one at a time, but I can also just scroll through them. I guess that's fine. Yeah. So we'll start with just a brief overview of what legal aid is and does. Legal Aid of Southeastern Pennsylvania serves the 4 counties around Philadelphia: Chester County, Montgomery County, Bucks County, and Delaware County. And the access point for anybody who has a civil legal issue in any of those counties is to call our helpline, 877-429-5994. They're not open all the time, but Monday to Friday, 9 to 1, you will oftentimes get a live person. If you don't, you leave a voicemail and they'll contact you back. And we cover all of these areas that I have listed. Lots of family law, lots of housing assistance, some consumer law, and we can file bankruptcies, lots of public benefits assistance, expungements, and sometimes dependency work. Okay. So I'm going to go straight past all of these. Okay. I think I'm going to start with why might an eviction happen? And there are 3 reasons that a tenant might be facing an eviction situation. Number 1, they're behind on their rent. Number 2, they've committed, or the landlord feels that they have committed a lease violation. They've breached the lease. And number 3, the lease term has come to an end and the landlord does not wish to re-rent, to re-renew the lease. Mostly in Pennsylvania, in the area of landlord tenant law, we are dealing with the Landlord Tenant Act of 1951. And you can put that phrase right into Google and it will bring you a PDF of the entire document. It's dense and the language isn't so clear, but I actually wanted to show it. So let's see. It deals with when a landlord can regain possession, what a landlord will need to do in order to start that process, and then also deals with a tenant recouping security deposit that was previously held. So I just wanted to show it. I don't know if it were me, I would like to see the actual paper, the actual statute that things are based on. So I have here highlighted the most important sections for tenants and landlords are Article 5, recovery of possession. And that is right here, Section 501, notice to quit. This is how all evictions will start. A landlord desirous of repossessing real property from a tenant may notify in writing the tenant to remove at the expiration of the time in the notice. So a lot of tenants will get a piece of paper on their door from the landlord that says notice to quit or notice to vacate or notice of non-renewal. This is to advise you that you must leave by X. And there will be a date specified. And again, here it lists the 3 reasons that might happen: termination of a term, forfeiture of the lease for breach, or failure to pay rent due. And down here, you see that the notice must be served personally or by leaving it at the same principal building upon the premises. So the notice to quit, technically, it should be handed to the tenant, personal service, or it should be posted at the apartment. A lot of landlords will send it by certified mail because they feel that is the most sure way, the best way to ensure delivery and receipt. That's not actually the way required by law. The law requires that the notice to quit be personally served or posted. And then we have here what happens upon the, okay, let me go back to my PowerPoint. Okay, so if the tenant receives a notice to quit and the tenant does not vacate by the date in the notice to quit, then the landlord can and likely will file an eviction complaint in the district court. There are 17 district courts around Chester County. It's the smallest court, the lowest level of court in the United States. All landlord-tenant actions must start there, according to the statute that we just looked at. And the procedures are, they're the same over and over and over. The complaint is a template form. The hearings proceed in the same way every time. The judgment form is a template form. And I wanted to share all of those forms with you as well. But first we'll look at, so here we go. So this is a pyramid showing the courts in the United States. Magisterial district courts are down here at the bottom. They're not informal, but they're quite informal compared to the Court of Common Pleas, the Chester County Justice Center here in Westchester. They are supposed to be accessible to a layman. So, you're a tenant who didn't hire an attorney for $2,000. That's fine. You can go in, you can access the hearing, and you have an opportunity to explain in layman's terms what your defense is. So here's the timeline for the hearing. Notice to quit. You received your notice to quit. It wasn't possible for you to vacate because there was nowhere else to go, or you disputed the reason that the landlord wanted you to quit. Maybe the notice to quit says you breached the lease and you feel that you actually did not breach the lease. Best to communicate with the landlord about that up front to avoid a filing if possible. But say avoiding the filing is not possible. The landlord continues to believe that you violated the lease and files the complaint. After the complaint is filed in the district court, smallest court, you will have a hearing scheduled. It's always 1 to 2 weeks from the filing, unless there's some sort of conflict and the district court is too busy. Sometimes it could be a bit further out. You receive notice of the hearing, both posted on your door again and mailed to you. It'll be 2 pages. The first page will say, you are summoned. Please come to this hearing at this time in this location. The second page is the most important page. It's the complaint. So it's the form, it's the same, it looks the same every time, but the landlord will check different check boxes that says what complaint the landlord has against you, why you're being summoned to this hearing, and what you must defend against. And then you see here, you would go to your hearing. Again, you don't need to have an attorney. If there's something technical, you can always call the legal aid helpline, and they'll provide you at least advice, possibly assistance and representation, depending on availability of our attorneys. And then after the hearing, the judge has up to 3 days to make her decision, which again, she will mail to you. This decision does not get posted on your door. It gets mailed to you. Sometimes mail can be slow, and the date of the decision is important because it triggers the timeline that you have to appeal. So if you're in this situation and you're waiting on a decision, 2 days go by, you don't have it yet, I personally would call the district court and ask what the decision is and if that could be emailed to me for efficiency. If there's a judgment against the tenant, which is not what we want, the tenant always has, at a minimum, 21 days before eviction would happen. A lot of people who aren't familiar with this process, it's very scary to get the court paperwork, posted on your door. You're summoned, you have a hearing, you're being evicted. They think, I'm going to be put out tomorrow. I could be put out I could be put out at any minute. And you can't possibly live with that stress. So it's important to understand that there is a hard timeline that cannot be broken. Complaint is filed, hearing will be in a week to 2 weeks, up to 3 days to make the decision. And then from the date of the decision, so say it was October 1st, no eviction can happen until at least October 21st. And in the first 10 days after the decision is made, the tenant can appeal. It doesn't matter if the tenant has no true legal argument. It doesn't matter if the landlord doesn't want the tenant to appeal. The tenant has a right by law to appeal the adverse judgment in the first 10 days and maintain possession. That can get tricky and complicated, but a lot of people do it if they don't have anywhere that they can relocate to as of yet. And it is possible. It's ongoing litigation. So once you file your appeal, it triggers the landlord making another more formalized complaint in the higher level court, in this court. And it triggers the tenant having to file a more formalized answer. And you have to pay your rent into escrow to continue the appeal. So we could talk more about that later. Okay, so I wanted to share the forms. So here we have the, here we have the complaint. So you received a notice to quit. You weren't able to quit or didn't feel that it was right for you to have to quit. The landlord filed a landlord-tenant case in district court, and you received this paper in the mail. This will be all filled out by your landlord. Usually landlord does it in his own handwriting. They check off that it's a residential lease. They indicate the monthly rent. They indicate whether you've made a security deposit. And then they have all these funny boxes. Most times, landlords will check here, here, rent remaining due and unpaid, and they'll write in the amount of rent that the tenant owes. And then they'll check here, additional rent, unpaid on the hearing date, because as time passes, more rent accrues. And then down here is also important. The landlord further alleges that notice to quit was given. Check these boxes. Look at number 4. Did the tenant in fact receive notice to quit, or is that false? The term for which the property was leased is fully ended. Check that. Check your lease. Is the term actually fully ended? Because there are property management companies out there that are, I don't know, poorly organized, and they will file a complaint claiming that the lease has ended when you look at the lease and it hasn't. Maybe the renewal clause in the previous year lease says this lease will automatically renew in year terms, year to year, absent 60 days notice of non-renewal. So if the 60 days notice of non-renewal wasn't properly met, the lease has already automatically renewed, and it's very possible that the term for which the property was leased is not fully properly ended. So pay attention to this paper and look at what the landlord is alleging. And that will help you determine how you're going to proceed in the hearing. A lot of leases, unfortunately, waive the notice to quit requirement. So probably two most important things to check in your lease are renewal term clause and whether the notice to quit is waived. A lot of leases will put that in all caps, so it's a little bit more attention grabbing, but not all of them. Sometimes it's just one little line in there. This tenant waives the right to a notice to quit. And that's not great, because that means you could receive one of these at any time. The landlord wouldn't have to provide you with any sort of paperwork in advance. Okay. So possible defenses. So you receive the landlord tenant complaint and you're preparing to go to your hearing and speak to the judge. In the hearing room, it will just be the magisterial district judge. Of course, the person does wear a black robe and sits a bit higher than everyone else, but nothing like what you see on TV, not the pomp and circumstance of that. And then the only other people in the room will be the landlord at the plaintiff's table and the tenant at the defendant's table. Landlord always gets to speak first because they're the one that filed the complaint. Typically, they'll just say a summary of what's on their complaint. I would like this tenant to leave because they didn't pay. I would like this tenant to leave because they're very noisy and they're bothering the neighbors, and that's a breach of the lease. Even though sometimes what the landlord says will be absurd and very upsetting, it's always best to wait until the landlord is done, just because the judge will be frustrated if each party isn't allowed to finish their thought. The judges like things to proceed just so. So I always recommend to bring a note paper and a pen. That way you can take notes about what the landlord is saying. Instead of interrupting, you can notate, okay, here's the quote that I want to bring back up and here's what I want to respond to it. After landlord is done, judge will turn to tenant and say, well, you know, what do you have to say? If the complaint is alleged breach of lease, I mean, obviously you're going to testify that you did not in fact breach that portion of the lease, and you can bring any and all evidence to that effect. If you have a witness, you can call your own witness up to testify. I have known this has been my neighbor for 10 years. All the interactions I've had with this person have been positive. I never hear noise or disruptions coming from their property. Sometimes people in the neighborhood don't want to be a witness because they don't want to get in the middle of things, especially if they rent from the same property management company. But it's persuasive to have a witness. I think it is. So consider that. And of course, you have your own testimony. If the allegation was unpaid rent, a lot of times that allegation is going to be true. The landlord has to be pretty silly to file an eviction complaint for unpaid rent when the rent's actually paid, but it happens. So you want to bring proof of payments made. If the complaint says that you owe July, August, September, and you paid July, don't just go yourself and testify, well, I paid July. If there's documentation of something, bring documentation of something. So bring your money order receipt, bring your, if you paid in cash, I mean, never pay in cash unless you get the landlord to sign a cash received. But sometimes there's a workaround, like if you withdrew that cash from your bank account, you can bring a printout of your bank account, redacting your private information and show, look, this amount, I withdrew this amount on this day in preparation to give it to the landlord. You want to bring confirmation of what payments were made, in what way, and when, specifically when. And a lot of times, if you do that, you'll be more prepared than the landlord, who simply brings the ledger and says, well, this is the ledger. This has got to be it. This is law. Ledgers can be wrong. I frequently see incorrect ledgers, especially if the tenant has a voucher. If they receive a subsidy through the housing authority is paying, behind the scenes on their end each month. And then the tenant is paying their portion each month. Sometimes the landlord doesn't correctly credit the housing authority's payment, and the landlord will be suing the tenant for the housing authority's unpaid portion when in fact it was paid. So definitely contact the housing authority. They have proof of payment, bring that. I would also say bring 3 copies of each document that you have. It's just convenient. You can hand one to the landlord, one to the judge, keep one for yourself to reference while you're talking. If the allegation is end of term, unless the landlord made a mistake, like we talked about, you look in the lease, the term is not really over, you explain that to the judge. If it is the end of the term, we're out of luck because there is no effective legal defense to a non-renewal. Of course, nobody is forced to contract with anybody else. So if the landlord just decides that they don't like the tenant anymore and they give the tenant proper notice that the lease won't be renewed, that's it. There's no defense. You can still take advantage of the court process. You can still stay past your notice to quit date if you have no other solution. The case will be filed against you. You wait to your hearing, you go to your hearing, you express to the judge that it's a sympathetic situation. There's these reasons why you've been unable to relocate, but always express that you're trying. Here's the places that you have searched so far. You can appeal, you can draw out your time in that property, even if it's a non-renewal, but there will be no success against a non-renewal. It will all be about how much time can you gain in order to relocate. Okay, there is at times an implied warranty of habitability defense. So say the claim is that you haven't paid rent, but in the tenant's eyes, they haven't paid rent because the property is just, it's not worth it. The property has too many habitability concerns. That can be a valid defense to the payment of rent, but you have to lay the proper groundwork. So I'm going to share my PowerPoint again. And go up to, okay. So the implied warranty of habitability is, of course, a very long and cumbersome title for we as humans have the right to a decent place to live. The landlord will provide a safe, a healthful, a clean home. Unfortunately, it doesn't guarantee a nice home. I mean, there are properties that are just truly sad that technically do meet with the implied warranty of habitability. But if they have any problems like this, plumbing issues, sewage system not working, can't secure the premises, maybe the door doesn't have a lock, it's been busted in, maybe there's no heat, maybe there's a serious rodent or roach infestation can be a breach of the implied warranty of habitability. So if there's something significant that affects the tenant's ability to live safely in the premises, not just ugly walls, peeling paint, not just clearly the place hasn't been recarpeted in 10 years, then you should lay the groundwork to possibly later use that as a defense or bring an affirmative claim against the landlord for that violation of the implied warranty of habitability. So first things first, you have this significant issue, you talk to the landlord about it. It's obvious, it's clear. Most people, though, will just talk. It's better, maybe talk first and see if that works. A lot of landlords might work with you. If that doesn't work, do something in writing. So a letter such as, "Dear landlord, we've spoken about this, but I wanted to follow up about repairs that are needed. Put your address, put what the repairs are with specificity, and ask that you receive assistance in a reasonable amount of time." You get to choose the reasonable amount of time. So say the problem is that the heat is not working and it's winter. The reasonable amount of time is going to be very short. Please address this issue. Please contact me. Please provide a resolution within 24 hours, 48 hours. If it's something that can wait a bit longer, you want to show that you're being reasonable. You want to say, please address this issue within 1 week, 2 weeks. And then you wait. And the hope is that the landlord will receive this communication and take it seriously and provide the assistance. If they have not, you've set yourself up to, at the end of that time period, send a second communication that says, Again, I'm following up on my previous letter. It has been 2 weeks. I haven't received assistance from you, and I'm going to exercise my right to withhold rent. And you want to withhold a reasonable amount of rent. If you can't use one room in the house and it's a 5-room house, you could escrow 20% of your rent. You can also just escrow the full amount to keep it simple. You want to make sure that the money is available, so not used on something else, available and set aside. If it's a tenant who banks and they have a savings account, maybe doesn't have anything in it, put the money in there. That way you'll have bank statements that show when it was deposited. Look, it was deposited on the 1st, the day that the rent was due. If the tenant doesn't bank, I mean, some people also just keep cash in an envelope, but that always scares me. And here's an example of the second letter. I have at the bottom a note that you shouldn't do this lightly. You should really only do it if there's a serious problem, because what happens when you withhold rent, the landlord often files an eviction complaint. Well, they serve you with a notice to quit, and then they file an eviction complaint. And that, even if in the end you ultimately win the case, is always going to be a civil record under the tenant's name on the Pennsylvania judicial records. So best to avoid that if you can. Prospective landlords do search it. Sometimes it's unavoidable. And so, you can call the helpline if you have a habitability issue. You're not sure if you want to exercise your right to withhold rent. So if you withhold your rent and you have laid the correct groundwork, you sent the first communication, no response or inappropriate response. You sent the second communication, you escrowed rent in the proper way, you have proof of that. And then the landlord files an eviction complaint claiming, think back to the prior form, checking the box that says rent due is not paid. You have the hearing date, you show up at the hearing with 3 copies of each document. Yes, Your Honor, I didn't pay that rent. It is outstanding, but that's because there are violations of the implied warranty of habitability that are not appropriate. Here are the photos, or here are the inspection reports, if the borough came out and did an inspection, or if you have a voucher, if McWright came out and did an inspection. Here is my bank statement showing that the money was available and that I escrowed it for this purpose. And then if you have a significant implied warranty of habitability violation, the judges will take that seriously and usually chastise the landlord. And it's very possible that that rent will no longer be owed. But it's also possible that if you're not successful, this ends in eviction. So I do recommend getting legal advice. I'm going to, now, if the implied warranty of habitability violation was such that you as the tenant had high or significant out-of-pocket costs, possibly there was no heat and you were, or the heating system was not working. So you were using space heaters to heat the property, and therefore which is scary, and therefore your electric bill was far greater than it usually is. You can make a cross complaint. The landlord has sued the tenant in eviction. The tenant can sue the landlord, file a civil complaint against the landlord. Those hearings will be held on the same day. And the civil complaint is, again, very simple form that looks like this. So the tenant would go to the district court, ask for a blank civil complaint form, fill it out with all the information. In this large blank section here, write their claim. So it can be layman's terms, but you would want to fill in something like claiming out-of-pocket costs incurred due to violation of the implied warranty of habitability. And this will be served by the court upon the landlord. At the hearing, you'll provide all the proof of the out-of-pocket costs that you had, you know, the receipts to purchase the space heaters, the electric bills. It's also important to know if the tenant is low income, filing this civil complaint, when you're filed against, when you're the defendant, the filing doesn't cost you anything. But when you are the plaintiff, when you are filing a cross complaint, there is a fee, and it's hefty. It's $165 or so to file a civil cross complaint against the landlord. So if the tenant is low income, it's worth filing this along with the complaint, which is an IFP, an informa pauperis, where you're explaining to the court, look, my income and my reasonable expenses are pretty much neck and neck. I don't have the money left over to pay this filing fee. And in that way, sometimes you can file it for free. It's about 2 pages here, mostly just putting in monetary amounts, what your income is, what your expenses are. Okay. So let's go back to okay. Illegal evictions. God forbid you have a landlord that does not follow the Landlord Tenant Act of 1951, the required procedure. Absolutely have to file in the district court, have the hearing, and get the judgment for possession if you want to remove a tenant. There are landlords out there who don't want to do that. They want to make it easy. They want to take a shortcut. So if your landlord, God forbid, puts your things outside, shuts off your utilities, removes the door, call our helpline, and it's possible that we'll be able to assist you with filing an emergency injunction to get back into the property. First steps, though, would be to call the police and show proof that you are a tenant. And a lot of times they'll instruct the landlord to let you back in and say, listen, there's a clear civil procedure for this. And you can't just put the tenant out. But it's good. Doesn't happen a ton, but it's good to keep proof of tenancy with you. So maybe like keep some mail with your name and address on it in your pocketbook or in your car in case this does happen, especially if there's a very rocky relationship with the landlord and you worry that this might happen in the near future. Okay, I also had I could share more images of court paperwork. So after the hearing, like we said, 3 days to a judgment, the judgment will come in the mail and looks like this. And here we go. There are 2 types of judgments. So let me explain this first before I share. So the landlord tenant hearing is always about 2 things. Well, unless the landlord is only asking for a money judgment and not asking for possession, but almost always when the landlord files a eviction complaint, recovery of real property complaint, they're looking to get some money and get possession of the property. So there are 2 pieces of the case that can move independently. The judge could award just the money, but no possession of the property. The judge could award both with sort of an ability to cure, or the judge could award both with no ability to cure. So again, think back to the 3 reasons that an eviction can happen: non-payment of rent, breach of lease, end of lease term. If the only allegation or the only meritorious allegation is non-payment of rent, the judgment will be curable. The judgment will be, remember, you can never be evicted earlier than 21 days after the judgment. So if the only issue was the unpaid rent, you'll have those 21 days to pay the rent and cure the default. And if that's the case, you'll receive an order for possession that looks like this. Okay, this is what comes in the mail. Again, if you don't get it in the mail after 2-3 days, call the court to preserve your right to appeal. Notice of judgment, residential lease. This is the most important section right here, possession details. If it's a pay and stay, if the only thing that the judge determined that the tenant did wrong was get behind on rent, it will say possession is granted. And at any time before delivery of the real property, in execution of the order for possession, blah, 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 the defendant may satisfy the order for possession by paying the rent actually in arrears. So you pay the landlord the amount of money that is listed down here under grand total. Your eviction should be stopped. Your judgment should be satisfied. There's a piece of paper that the landlord needs to file that says entry of satisfaction. Make sure that the landlord files that. You know, it might be good to, well, if it's a trustworthy landlord, then I'm sure they'll do it. But with the shysters out there, it's good to have them sign the entry of satisfaction at the same moment that you're paying the funds to ensure that the payment of the funds will stop the eviction. I have had it happen where a payment was made and the landlord, you know, maybe refused to answer calls, maybe kind of disappeared, but did not advise the court that satisfaction was made. And so the eviction will go through anyways, which is terrible. If that's happening, definitely call legal aid, and we can probably possibly petition, emergency petition the Court of Common Pleas to stop the eviction, but you want to avoid that. Okay, if the judgment is for straight possession, there's no opportunity for the tenant to cure it before eviction. It will look like this. This will come in the mail instead. Possession is granted, and the defendant is not permitted to satisfy the order by paying the rent in arrears. If you receive one of these, you have lost, and if you're planning to stay in the property longer, you need to appeal within 10 days. Okay, so it's 12:40, so it's a little early, seeing as how this is to be an hour, but I think I would prefer to open it up to questions and have more of a back and forth, if that's okay with everybody.
Okay, thank you, Kelly. That was really thorough, but I will stop the recording now. So if anybody does have questions, they can ask. So here we go.